Yes. Okay. Start letting people in. Let Serena do her thing.
Did y'all get a notification saying it was recording?
Yes.
Yes.
Welcome everyone. I'm just letting everyone get in really quickly. Some people are still connecting to audio, but welcome. All righty. Well, welcome all of you to our series, our Navigating ALS series. Today we will hear from Miss Lisa, and she will be talking to us about estate planning. I'm just going over some rules. We ask that you please keep yourself on mute. If you have any questions, concerns, comments, anything like that, we do ask that you please utilize the chat box. There will be someone monitoring this chat box as the presentation is going forward, and we will get those questions answered. Okay, so with that being said, I'm gonna go ahead and pass it over to Jordan.
Hi, everyone. Hope everybody's having a good day. It's my pleasure to introduce our speaker today, Miss Lisa Wilson. We're really grateful for her time and expertise. So I wanted to tell you a little bit about her. She received her Bachelor of Arts from the University of Texas at Austin and her Doctor of Jurisprudence from the University of Houston Law Center. Her law practice has focused on assisting families who have a child with a disability, and she has extensive experience in special needs trust and guardianship matters. Additionally, she is a frequent speaker for disability support groups in area school districts, special education parent groups. She is experienced in probate, estate planning, and guardianship law. And we're just really excited to have her here. And yeah, I know this will just be meaningful to all of us. So thank you so much, Lisa, and I'll pass it off to you.
Okay, thank you. So let me see if I can get my slideshow going. I don't, let's see.
Samantha may have to unshare her screen.
I just unshared it. It should be at the bottom of your screen, like a little green arrow.
Okay. Can you see my screen now?
No, ma'am. Oh, yes.
There we go.
Okay. See if I can get the slideshow to start going. Sorry.
You're okay.
Well,
Right there.
somewhere I know I
says,
saw, go ahead.
where it says from the beginning on the left-hand side, right underneath file.
There we go. Thank you.
You're welcome.
And I presume, okay, there we go. So, so estate planning and planning for incapacity, those are generally sort of the two components of what is really under the umbrella of estate planning. Estate planning generally addresses transfer of assets upon your death, and also how to deal with potential incapacity. So starting off with transfer of assets upon your death, usually we're talking about a will, last will and testament, and within a will, we can create trusts. And the purpose of trusts would be generally, trust can serve all kinds of purposes, but generally would be for the management of assets for someone who's incapable of managing their own inheritance, such as a minor child, person who's incapacitated. As an alternative to a will, we sometimes utilize revocable living trusts. And with a revocable living trust, an individual or a couple would create a trust agreement and then generally move their assets into the trust, have their assets retitled in the name of the trust. So in the event of incapacity or death, it's a smooth transition to the next person in control, the successor trustee. And then the trustee would have the revocable living trust as their working document on how assets are managed for the benefit of the beneficiary or beneficiaries. Subsequent trusts can be created from the revocable living trust, just as we would do in a will. Again, if someone with someone who's a minor or someone with limited capacity is unable to manage assets that would be directed for their benefit, then the revocable living trust could create additional trusts. So there's often this kind of tough threshold decision to be made of whether you go the will route or the revocable living trust. Wills have sort of historically over the years gotten kind of a bad reputation because there's always the horror stories of probate. But most practitioners in Texas will default to a will because we do have very efficient, very streamlined probate laws. So in general, the probate of a will is a speedy process. You can do exactly the same thing as far as disposition of your estate, planning for the event of your death with a will as with a revocable living trust. There's no tax benefit of one or over the other. It's basic, it's the same. So again, we would look at the particular circumstances of the couple or the individual. If there's real estate, for example, that is owned in a number of states, then we may decide a revocable living trust makes sense because real estate is very much tied in to the laws of that land where it's located. And so in the event of a death, there may have to be ancillary proceedings in a number of states. So to bring all those properties under a revocable living trust could make things more streamlined. Pause to take a drink of water. So depending on what assets a person has, we may be able to avoid doing a will or a revocable living trust. A transfer on death deed, that's a way to transfer real estate without having to go through probate or any other process. The document says basically, I'm keeping this property as my own for as long as I live. I may even decide to sell it before I die. But if I still own it at the time of my death, it immediately becomes the property of my children or whoever. Beneficiary designations, as you might be aware, many assets will pass outside of the probate process, or even outside of a revocable living trust in some circumstances by beneficiary designation. So typically those would be 401ks, IRAs, life insurance. And it's important that those beneficiary designations are set up correctly. You don't want to name a minor. You don't want to name a person with a disability directly. In both those circumstances, you may want to name a trust for their benefit, but generally not them directly. There are different tax consequences with IRAs and 401ks depending on who the beneficiary is. So a lot of attention needs to be paid to that. And you need to know what your contingency plan would be and make sure that's addressed in a beneficiary designation as well. So multi-party accounts with survivorship designations. So oftentimes husband and wife will have a joint operating checking account. And most of the time that would be set up with a survivorship designation, meaning that in the event husband or wife dies, the property is automatically the sole property of the surviving spouse. Payable on death bank accounts, or transfer on death accounts, brokerage accounts, operate like beneficiary designations. In the event of my death, any assets remaining in this account will pay equally to my children or something like that. So I guess I should back up because I was going to spend more time on the incapacity documents. Are there any questions on wills, trusts, for starters, before I move ahead?
I don't see any in the chat just yet, but I'll give it a second and then and make sure there's not somebody typing it in as we speak.
Okay.
But certainly everyone, if you do have a question, feel free to put it in the chat box and I'm just kind of monitoring that. And Lisa just said for me to let her know when there's one there. So we'll make sure that we can address any concerns y'all have.
So the second major component of a typical estate plan that we would do would again address if the individual became incapacitated. Who's going to make financial decisions for you? Who is going to make medical decisions if you were to become incapacitated? So joint accounts are one way to do that. I am currently serving as agent under a power of attorney for my 94-year-old dad. And the bank suggested we put together a joint account, and that's really worked well. The second bullet point there is a statutory durable power of attorney, financial power of attorney. So that document is prepared by someone who, or executed by someone who has capacity at the time. They have to fully understand what they're signing, the powers that are being granted and under what conditions, but they can designate an agent that would have access to all their financial instruments, all their bank accounts, all their investment accounts, and be able to handle any type of business or financial matter that would arise. It can be made effective immediately at the principal's choosing, or it can be made effective only when the principal is determined by a doctor to be unable to manage their own affairs. Again, a revocable living trust is a way to structure your assets in the trust instrument, have them retitled, transferred to the trust instrument, and then have a successor trustee that could take over when the principal becomes incapacitated. They would have the authority to manage all the assets within the trust, those assets that are titled in the name of the trust, according to the terms of the trust agreement. A supplemental care trust, also called special needs trusts. So these are trusts that would allow a beneficiary to receive benefits from a trust, but the existence of the trust would not cause them to be ineligible for government benefits that are based on a disability, and financial need. So generally, we're most concerned about Medicaid when we're setting up the supplemental care trust or special needs trust. Medicaid provides so many benefits to people with disabilities that otherwise have limited assets. So the supplemental care trust kind of comes in two types. There's what we call a third-party trust. So we draft a lot of third-party trusts, primarily parents who have kids with disabilities, or it could be a spouse who has a spouse who has become disabled, and they want to be able to leave property to that spouse or to that child in the event of their death, but not force them off of benefits that might otherwise be really helpful for their care. Then there's a first-party special needs trust. And so a first-party special needs trust is funded with the individual who has the disability with their own assets. So if they have assets and become disabled, or if they are on benefits and then somehow come into some money. So the usual sources of that money would be maybe an injury settlement. Sometimes the reason the person has a disability is because they've been injured. Sometimes it's an inheritance that they receive. We can set up a first-party special needs trust or supplemental care trust. The key difference between the third-party funded and the first party is that a first-party trust has to provide that when the individual dies, Medicaid gets reimbursed from any remaining trust assets for the amounts they have paid out during the individual's lifetime. Okay, next on the list, payee representatives, or I think I usually see that representative payee, but that's for Social Security disability benefits. If Social Security determines that because of the person's disability, they're unable to manage their own benefits, then Social Security will appoint a representative payee. And that person will receive the benefits on behalf of the person with the disability, and they'll be in charge of managing those assets. And generally, they have to report back to Social Security on an annual basis on how those funds were used. And then finally, guardianship. So guardianship generally is not our first choice. That is a court proceeding that sets up a relationship between the person under the guardianship and a guardian that the court appoints. There is a guardianship of the person. And in that circumstance, the guardian would have all the decision-making authority for the person with the disability regarding their medical treatment, their care, their custody, where they live, would be their advocate, their care advocate. And then there's a guardianship of the estate. And so the guardianship of the estate gives that process gives the guardian authority over all of the individual's assets, and they are reportable to the court on the management of those assets. So they have to be bonded on the value of liquid assets, an annual income. They have to set up a budget for court approval. They have to have a management plan for the assets, and they have to report annually an accounting that would include all receipts, invoices, bills, everything. Has to balance to the penny. So generally, we encourage clients to get the good powers of attorney, trusts, beneficiary designations, whatever in place, so, or multiple accounts, to avoid the necessity for the guardianship because it's costly and things move very slowly. But the flip side is the guardianship can be really good protection for an incapacitated individual. Most courts, especially in like Harris County, Montgomery County, these courts take their job very seriously in trying to protect the incapacitated person. Like in Harris County, there are specialized probate and guardianship courts. And so these judges are perhaps a little more knowledgeable about the process, but each court has maybe a couple thousand guardianships that they have to be in charge of. So things do fall through the cracks.
We do
Any
have a
questions
question.
so far?
Yes, we do have a question. All right. So if you have a revocable living trust, can you add a supplemental care trust? Can Social Security payments go to the revocable living trust and then pour into the supplemental care trust?
Well, again, if the supplemental care trust is for the benefit of another person, like, or I'm not sure if we're talking about a first party or third party trust.
I'm not sure either. Bill is living with ALS who asked the question, but I'm not sure if, and he's quick to respond. So he said, so he's talking about himself for Bill. So yeah, he's just saying, would you like me to read the question again too? Because I know I read through that kind of fast.
No,
just
that's
'cause we
okay. I
read
think
through.
I
You
got it, but
Okay.
if, so the first question is, I'm not sure if Social Security would pay to a trust account. It might have to be an account in your own name. Maybe they would, I'm not really sure, but so yeah, if you on a monthly basis, you got your Social Security payment and then directed it into a supplemental care trust. Of course, the purpose of the Social Security payments is first to go pay for your room and board, wherever you are. And so then any excess could be placed into a first party trust. A first party trust is limited by the individual's age. So you can only create and contribute to a first party trust if you're under the age of 65. Once you reach 65, you can't create it. You can no longer make contributions. But excess Social Security is often what we are funding first party trusts with. Usually it's because it's been received in a lump sum. Hope that answers that.
So he's just said to clarify, so it would be a third party then.
So a third party special needs trust is a trust that you would be setting up for someone else. So third party means anyone can place assets in the trust except the person with the disability.
Okay, and he said, so their goal is to protect income over the limit for Medicaid. Medicaid, yeah.
Not income. That's a different kind of trust. So,
Okay.
So for Medicaid eligibility, they look at assets and income. And so if it's your own assets and you're trying to get Medicaid eligible, well, that's probably beyond this discussion, but you could move your, as long as you're not yet 65, move all your assets into a first party trust. But income, if your income is too high for Medicaid, that's almost always hardly ever an issue because we have what's called a qualifying income trust. And so if your Social Security income and your other income goes over, I don't remember what it is now this year, somewhere around $2,500 a month generally, but each Medicaid program has its own monthly income limits. But for a lot of the major programs that provide full care, it's somewhere around $2,500 a month. So if your income is over that, then we go through this bit of silliness called a qualifying income trust, where you put your income in a trust account. There's a very brief trust agreement. And then from that trust, you get to keep $60. Again, depending on what kind of Medicaid program it is. This would be like a typical nursing home Medicaid. You get to keep $60 personal needs, and then the rest goes to pay for your care. And if you're short of paying for your full care, Medicaid pays the difference. So income above the Medicaid limit for a lot of Medicaid programs is not really a problem we can't overcome. Assets are a big issue. So joint accounts. So again, this is a way to deal with incapacity and allow someone to manage assets for a person who's incapacitated. And then you would want to pay a lot of attention to how that is structured, because a lot of times banks will just choose their own defaults and may add a right of survivorship provision. Maybe you want that, maybe you don't. Maybe one child, let's say, or one family member is going to help you with that account, but you don't really want the whole account to go just to that person in the event of your death. You want it to go to all of your children. So you may prefer to have a payable on death or have no sort of beneficiary. So it just passes under your will with all the directions and contingency that a will may provide. Again, acting as agent for my dad, the bank that he likes to bank with, being ex-military, USAA, they will only create a joint account with right of survivorship provision. So every month I send my siblings an accounting of that account, just so they know I'm not. So they'll know what's in there when dad dies, because I know his intent that it goes to everybody and not just me. The convenience signing account, again, most, as it says here, a lot of banks don't know what we're talking about. So the law allows it, but not all banks will offer that as an option. But basically, you can name another person who only has the right to sign checks, pay your bills, but they don't really have any right to any of the assets. And generally, while people are alive and they have a joint account, the account really belongs to whoever put money in. But then at death, if there's no survivorship provision, then generally it would pass as part of the estate under a will. So a financial power of attorney, there's a warning on the Texas statutory form that the powers granted in the financial power of attorney are very broad and sweeping. You can withhold some powers. Generally, we don't recommend that for our clients. I mean, most of the time you want your designated agent to be able to handle whatever might come up. So we try to leave their authority as broad as possible. It can be made by the principal effective immediately, which is what we usually recommend, or effective upon the person's disability, which means when a doctor determines they're no longer able to manage their financial affairs. effective immediately is something that at first glance, the client's like, no, I don't really want to do that. But we talk to them about it because we think that makes the most sense. Again, looking to me and my dad's relationship, he's confused a lot. And he says, can you do this for me? And it's nice to be able to do that without that declaration of incapacity, without having to take him to a doctor and have a doctor say he can no longer manage his affairs. A doctor has told me, we hate to do that. I said, no, I didn't know that. But I think it's hard for a doctor who sees you for a relatively short period of time to really know what the patient's capability is in managing their own affairs. And what is that opening the patient up to if they write a letter to that effect? So effective immediately, it's interesting to see how people will say, oh yes, I'll trust this person to do all these things listed. But then when you get to effective immediately, they're like, well, I don't know. What if they come in and clean out my bank accounts? I'm like, look, you're going to trust them totally when you wouldn't know if they did that. So wouldn't you trust them while you would know if they did that? So again, usually effective immediately makes the most sense. You may not be incapacitated. Maybe you're just recovering from surgery, and something needs to be done. We used to have a lot of difficulty with powers of attorney being accepted. Banks would have their own rules. Well, we don't take them if they're more than 2 years old. And I think the legislature got kind of tired of hearing those stories and passed some legislation a few years back that banks really had to accept them unless they truly believed a fraud was being committed. And then they had to act on that and report the potential fraud. So it seems to be a little better now. So this is a list of the broad categories of powers that are granted under a power of attorney. And then again, you can withhold any by crossing those out. And our statute takes each category and lists in depth and in detail what exactly those powers are in each area. And then we have what's called the hot powers. So these are added periodically by the legislature to allow the individual to grant expanded powers. So like the power to gift, power to make a trust. And this one, I have my suspicions about why most of these were added, but the trust provision, I think really came from Medicaid and the ability to create those qualifying income trusts. So the legislature flip-flopped the default. It used to be the default was that an agent could not compensate themselves, and you had to specifically grant that. Now the default is they can pay themselves unless you disallow it. I think I'll skip over this one. So back to the living trust as a tool for incapacity. That's another circumstance where we will often consider using a revocable living trust. And that's if I have an individual or a couple who incapacity is kind of right around the corner for them, and they're ready to turn over control to the next generation. They're really ready to have the kids managed because they're not feeling as confident in their ability to do that. The other time we use it is for the individual who really doesn't have anyone that they are comfortable naming as an agent under a power of attorney or as an executor of the will. Then we may create a revocable living trust and have a trust company as the successor trustee. So all the assets, or as much as we can, we get retitled the name of the revocable living trust. And if the person later becomes incapacitated, then a trust company would step in and manage for their benefit. I think I've kind of gone through some of this. Avoid probate, but again, that's not that burdensome in Texas. We do have a very streamlined and efficient probate process. Again, if there's property in other states, that would be a big deal. Planning for incapacity. Yeah, less likely to be contested. If a trust is set up and it's managed for a number of years, it's hard to say the person didn't know what they were doing. For the signing of a will, you're really looking at the moment the person signed it. Did they understand what they were doing? Did they have capacity? Did anybody exert influence over them? But a revocable living trust has a little more of a track record. The person's their own trustee. They're handling transactions in the name of the trust. So it's harder to argue that they didn't have capacity. So if there's an expectation that there's going to be problems when the person dies, sometimes a trust is a good option. Again, what makes people think they want a trust is they think they're going to get asset protection. They think if they move everything into a trust, it won't be counted for Medicaid, or that, if they were to get sued, it would be protected. But in general, if you move your own assets into a trust, continue to benefit from those assets, you're not going to get any sort of creditor protection or Medicaid protection. Okay, I think I talk out of order, so I get talked too much earlier about this. But these are basically the points, again, of the supplemental care trust. So the first party trust, beneficiary's own assets, has the Medicaid payback, can only be created and funded if the person hasn't yet reached the age of 65. Third party trust, much more flexible in the provisions. Anyone can create one for another person at any age, and it allows the person to have the benefit of the assets in the trust without affecting their benefits. So again, that's a lot of the planning we do for parents who have kids with disabilities. So these kids are relying on benefits, but we do a lot of spousal supplemental care trusts too. So if a spouse is incapacitated and maybe they expect to be looking to get on benefits in the future, then other spouse in their will, rather than saying, if I die, I leave everything to my spouse. If I die, I leave all of my estate in trust for the benefit of my spouse. Then those assets won't be counted when the spouse is applying for benefits. Back to the representative payee. So the government agencies generally don't recognize powers of attorney. They have their own, they do their own, or even guardianships. Social Security will name its representative payee, and the VA will name its own fiduciaries and have them report directly. So medical decision-making, what we're primarily going to talk about is in the event that a person loses the ability to make their own medical decisions. There is some statutory provision under law, but it requires that a person be in a institutional setting. Then there's a priority of decision making. So a power of attorney, a medical power of attorney, can be really important to make sure you select that person that you want to be able to make medical decisions on your behalf. This is not a now or later, like the financial power of attorney. It's only once you're unable to make your own medical decisions. And then once that is the circumstance, basically the medical agent's authority is absolute, and they can make any and all decisions regarding your healthcare, up to and including consenting to or refusing life support. So there are some things that the medical power of attorney is limited in their authority: inpatient mental health services, convulsive treatment, psychosurgery, or abortion. So the directive to physicians, also known as a living will, is a way for an individual to express their preferences regarding life support. So it generally gives two scenarios. The first is a terminal condition. So that, I think, is describing basically a pretty advanced state of disease where you're expected to only survive for 6 months with or without life support. So you can choose whether you would want life support withheld, and basically a hospice definition there, hospice circumstance. You would be given the palliative care, allowed to die gently with comfort interventions given. Alternatively, you can direct that all of the life-sustaining treatments be administered. The second choice is the second scenario rather, is an irreversible condition. So this might be a coma, or it could be someone who has very advanced disease condition where they're no longer able to swallow, or maybe even dementia, but they are no longer able to swallow. And so the question of the feeding tube comes up. But you don't necessarily have that 6-month time frame. And then your choices are the same: withhold or don't withhold. So the directive, can be, this is the standard statutory form, but a directive can be very specific. So you can talk to your doctor about what kind of choices would need to be made in the future. What are the questions that are going to come up? What are the choices? And what if you're not in the position to be able to make those choices? You can craft a directive that is really specific to your condition, your disease, what the expectations are, and your wishes. And that becomes the guidance for your medical agent, the person who would be making these decisions in the event of your incapacity. So generally, the agent has ultimate authority. This is an expression of your wishes, but even here you can see this is two neatly defined black and white scenarios, which life doesn't always happen that way. It's much more fluid, like whether you're actually in an irreversible condition or a terminal condition. Maybe it's not known exactly when that occurs. And so keep in mind that the person you choose, that you name on your medical power of attorney, is making these decisions. And this is guidance for them. But ultimately, it's their decision. And we are all about the documents here and making sure they're signed and initialed and notarized and witnessed and everything. But this area is an area where you also just have to have talks with the agent. You really have to talk about it. And so that sort of came to light many years ago when Terry Schiavo was the patient in Florida, and her husband was the guardian and wanted to terminate, and her parents thought she was responsive and didn't want to terminate the life support. And the doctors were saying that whatever looked like it might be responses to the parents was really just inadvertent movements or eye movements or whatever, that she really wasn't responsive. So after that case, there was a lot of attention focused on directive to physicians and our forms and cases in Texas. And oddly enough, what came about that scrutiny was how many times these documents were challenged, but they were challenged on the basis of, oh yeah, I see that she signed this, but she was in the lawyer's office that day signing scads of documents. We never heard her say that. I don't think that's what she wanted. I just don't believe that. So it turns out that we try to encourage people to have those discussions so the whole family knows. And there's a place on the directive that allows you to write in some special instructions. And so I always want my clients, if they choose to do that, to write it in their own handwriting, usually their own words, unless I think they're creating an ambiguity. So I'll try and work through the language to make sure that it's really clear that that's what they wanted. So guardianship, we usually prepare for guardianship when we're doing estate planning documents by having a client sign a designation of guardian before need. If all the other documents are executed in good order, we generally can avoid getting a court involved. So there's planning done ahead of time. Sometimes we have to get a court involved if we need the authority of the court. And unfortunately, sometimes that's exploitation. When people become vulnerable because they start to lose mental capacity, there's plenty of people that would take advantage of that circumstance. So, and sometimes it's family. So if that happens, then sometimes we do have to go the guardianship route and for the best protection of the person. I think that's really that. And if someone just has not done any planning are the times that we have to go guardianship. So it's a lot of expense. And things happen very slowly, and almost every action of the guardian needs to be submitted to a court for prior approval. So again, very expensive attorney's fees, court costs, very slow moving. Something to generally be avoided if possible. And it is sort of a last resort. The court wants to hear that all the alternatives have been explored. So is it getting a caregiver to come into the home 3 times a week? versus having to have someone's rights, someone's autonomy removed by the court. This slide talks about, usually it's a family member who comes in and says, you know, this person is losing the ability to manage their own affairs. They don't have any documents in place, or someone's exploiting them. I need to pursue guardianship. This is just a way to let a court know that there's a person that you have had contact with that you believe the court needs a guardian. So that might be, sometimes it's a family member who just can't serve as guardian for some reason, but they know the person needs to have someone appointed to be their guardian. Then they can provide this information letter to the court, and the court would then send out an investigator, usually someone with a social work background that's on the court staff, sometimes an attorney, to kind of look into matters and make a recommendation. So key recommendations: everyone should have a plan in place to direct transfer of assets in the event of their death, whether that's a will, revocable living trust, or having accounts set up that can transfer directly or transfer on death deed. Everyone should have statutory durable financial power of attorney for someone to handle financial matters, medical power of attorney, medical advance directives. Of course, if you can, long-term care arrangements, and we call it a roadmap, which might be a silly term, but that's giving the people around you the go-to place. If something happens to me, this is where you go. If that's a binder or a portal, and then everything they need to know is there. So I have a binder at home, which I was trying to show to my son the other day, but he wasn't really paying attention. But it was all my estate planning documents, where the originals are, deed to my house, my life insurance policy, my marriage license, my birth certificate, my social security, copies of everything he would need, contact information for people who would be important either for financial issues or just to be support. Friends that would want to know if something had happened to me and I could use that kind of support. So again, making that go-to place so that information and that direction can be found. Okay, I think that's it. Any questions?
Thank you so much. I really appreciate all the information you had to share, and I'm kind of monitoring to see if any questions come through. So certainly anybody, if you have a question, please feel free to type it in the chat box. I'm kind of looking at that. But that was so much great information. So thank you so much for that.
Sure.
And as I'm just waiting to see if any questions are coming through, I wanted to let everyone know that it was recorded and we'll send out the recording. Lisa graciously offered that we can include her email address in the recording follow-up. So if you have a question or if something comes to you later on, you can email her a question about your question about whatever the information that she shared. Our next presentation will be February 13th. So look for that in your email inbox about of the upcoming series. And I don't think, yes, we're just getting lots of thank yous in the chat. So thank you again from all of us for speaking. And, you know, you may get a few questions to follow up in the email, but
Sure.
just thank you so much for your time. And yeah, everybody's saying thank you in the chat for taking the time and sharing your expertise with us.
You're very welcome.
All righty. Well, everyone have a great day, and we'll see you at the next series on February 13th.
Thank you.